Good morning, everyone. This is Ifama Otalami. I'm going to wait for people to come in. And let me put on the comments so I can see your comments. So when you come in, please feel free to, put in the comment section your name, where you're calling from, or where you're watching from. So today, I'm really excited to share this topic. And basically, we have a new policy directive from USCIS, and it's policy guidance where, basically this is USCIS telling us how they intend to act in certain capacities, certain situations. So there's a new policy directive that came out on February 10, 2022, which regards to VAWA. And I want to talk about that. I'm excited to talk about that. And I'm going to try not to go all legalese, because this is such an exciting um, topic. And I read the court's decision on this case. I'm going to be talking about a case called um, Arguijo versus USCIS. I'm going to be talking about that, and I'm going to try to just give you the bottom line, even though I really want to dig into it like I was in law school, because I really love to read court decisions that go my way. So, hi everybody, how is everyone doing? So, let's get into this. So, the topic I'm talking about is Violence Against Women's Act, right? I think you guys must know what that is. Violence Against Women's Act is a congressional a congressional uh, enactment of a rule that affords protection to immigrants who are married to U.S. citizens or green card holders, or are the children of U.S. citizens or green card holders, or are the parents of U.S. citizens who are over the age of 21, or what else? Stepchildren too of U.S. Citizens or green card holders, as long as the marriage took place before uh, took place when the child before the child turned 18, and the child filed before they were 21. So that's the basis of this case, called Arguijo versus USCIS. So I'm going to give you the background, and then we can get into it, and I can tell you why this is really exciting news. So Arguijo was born in Honduras in 1987. She came here with her mother, and her mother, who's also from Honduras, married a U.S. citizen in 1999, when Arguijo was about maybe 11 or 12. Due to abuse, which is abuse to her mother and abuse to Arguijo herself, the relationship broke up. So Arguijo's mother divorced the U.S. citizen in 2004. And Arguijo apparently had run away from home when she was 15 due to the abuse that her stepfather was subjecting to her, right? So, so her mother died, but Arguijo decided she could file under VAWA, and rightfully she could, because uh, she filed the step relationship between her mother and her stepfather occurred. The marriage occurred before she was 18, and she filed the VAWA petition before she was 21. So typically that should have been an okay, that should have been an okay filing. But USCIS denied the filing because they said, well, you lost your position as a stepchild in 2004. So therefore, you are no longer a stepchild, and therefore you cannot file. And so the case went up the ladder, and it kept being denied. Arguijo's case kept being denied until it got to the Seventh Circuit, and they are the ones that wrote the decision. And this case was actually from 2021. It was in March 12, 2021. That's when it was the decision came down. But just recently, USCIS said that was going to be its policy. Basically, what this court ruling was, it's going to be their policy. So the court said um, they disagreed with USCIS and the lower court that felt that the step relationship had ended. Now, in immigration, there's a difference between um, a child and a daughter and all that. So if you're a child, if you're under the age of 21, your daughter or a son, if you're 21 and above, those words really have meaning. And as a stepchild, like I said, you're only a stepchild if the marital relationship between your parents occurred before you were 18. And typically in USCIS, in immigration world, you can file for a step parent as long as you continue. You can file for a step parent after a divorce as long as you continue to have a familial relationship with that step parent. As long as you can prove that you continue to have a familial relationship with the step parent, then you can file for the step parent even if your parents are no longer together. But the court here said, huh? Literally, that's what they said. HUH question mark, like WTF. This makes no sense. It makes no sense for VAWA because to tell a stepchild that they can only file for VAWA if they continue to have a relationship with the abuser basically goes against everything VAWA stands for. And the court in the Seventh Circuit said this line of thinking, which was from a previous case, that case was made that decision prior to the enactment of VAWA in 1994. I think the name of the case is Mora, which is a 1981 case. So the Seventh Circuit was pretty much saying this has no application to VAWA, which was enacted much later after that court decision in Mora. So basically, this court is saying a stepchild relationship survives divorce. It doesn't matter if the parents are no longer married. If you were under the age of 18 when your parents were married, and if you file for VAWA before 21, it doesn't matter if the parents are not together anymore. You can be afforded the relief that you seek as a VAWA self-petitioner. And this makes a big difference in the lives of VAWA because VAWA is special, because that relationship, which should, the relationship with a US citizen or green card holder, which should give you status, if it's abusive, then you can give that abuser additional powers over the VAWA petitioner. So that's what this court said. The court said that a stepchild relationship survives a divorce. And USCIS said, yes, we agree, even though this is not what we have been doing in the past, but we are going to follow this ruling because it makes sense. So the decision is Arguijo versus USCIS, which allows stepchildren and step parents to continue to be eligible for VAWA self petitions if the parent and step parent are divorced. So that is the ruling, the policy guidance that came down on February 10, 2022. So if you know anyone who has either been denied by USCIS because the step relationship no longer existed, you might call us. We'll refile for you, or if it's happened recently and is within the period of time where we can file an appeal, we can definitely do so. Okay. So that policy guidance actually also touched on a couple more changes or a couple more highlights which USCIS intends to follow, and I will share them at another Facebook Live. I just wanted to bring this today because it's important for people to know their rights, especially immigration rights. What is there that you can do? What are your rights? What are the relief that's available to you as an intended immigrant? If you know this, then you know what to do. So let's see who's on the. I have Rachel. Hi, Rachel. How are you? Where are you calling from? All right. So I don't have any questions here, but this is actually a short one. But remember, I'm just going to go over what VAWA stands for. VAWA is a humanitarian pathway to citizenship, right? if you're the victim of abuse, it could be emotional abuse, psychological abuse, physical abuse, um, financial abuse, sexual abuse, it does, you can file for VAWA if you're the spouse of a U.S. citizen. Now we know that if you're the stepchild, you can file for VAWA as long as you meet the two criteria, which is that your parents got married before you were 18 and you filed before you were 21. And even with regards to the age of filing before you're 21, there's a little leeway given up to 25. You can file up to the age of 25 if you can show that the reason you didn't file when you were 21 was related to the abuse. All right. So that's it for today. My office is here to assist you guys. We're in New Jersey. Our phone number is 973-993-1900. Please follow us on social media, Facebook, Instagram, LinkedIn, YouTube, and TikTok for more immigration news and more immigration tidbits. Take care.